You slide the Delaware single-member LLC formation documents across the desk. His hand hasn't touched them yet. You already know he'll sign. You've done this for nearly 20 years. Not because you enjoy watching people sign things, but because you know what happens the moment pen hits paper. From that point on, this man is legally invisible. No property, no accounts, no equity, nothing. He's sitting across from you in a suit that costs more than most people's monthly rent, a Patek Philippe on his wrist. But pull a credit report right now, serve him a subpoena, and you'd find a ghost. That's the job, making wealthy people legally disappear. You grew up in a blue-collar family in Passaic County, New Jersey. Your dad was a factory floor inspector. Your mom ran a register at the grocery store. You got into Rutgers Law not because you had some vision of justice, but because law school was the clearest path you could see that didn't require asking your parents for money and still paid a livable wage. You graduated with just under $110,000 in student loans, interviewed at 7 firms, got 2 offers, a community legal aid clinic at $42,000 a year, or a boutique midtown Manhattan firm specializing in high net worth asset planning at $86,000 plus performance bonuses. You took the midtown job. You told yourself, pay off the debt first, then worry about ideals. At the time, that seemed completely reasonable. Your first 2 years were foundational, drafting wills, setting up revocable living trusts, helping retired physicians transfer property to their kids to minimize estate tax. All legal, all textbook. But you noticed the firm's real profit center was somewhere else entirely. The cases that let the senior partners leave at 4 in the afternoon to go play golf, those were a different category. Asset protection planning. The distinction matters. Estate planning is about passing wealth down. Asset protection planning is about hiding it, shielding it from creditors, divorce attorneys, and potential plaintiffs, all while staying technically legal. Delaware and Wyoming corporate law leave enormous room for this. A single-member LLC can achieve near total ownership opacity. Stack a Nevada holding company on top of that, crown the structure with an irrevocable trust, name your children or a designated institution as beneficiaries, and once that architecture is in place, the assets no longer legally belong to you. They belong to the trust. You're merely the trust protector. Real influence, 0 legal ownership. You spent 2 years learning this cold, not from textbooks, from sitting in the conference room with the firm's senior partner, Garrett, pulling cases apart piece by piece. Garrett had 30 years in the business. He said one thing you never forgot. Courts can only chase what's in your name. If there's nothing in your name, they're standing outside, knocking on glass. The first case you designed yourself, rather than executing someone else's plan, came in your 4th year. The client was a commercial real estate developer out of New Jersey, mid-50s, headed straight for divorce proceedings. 3 commercial properties in his name, combined assessed value just under $23 million. If the divorce moved forward, those assets were going into marital property division. He came to you with 2 options in mind: fight it out with the divorce attorneys in court, or move the assets now into an existing family LLC. You knew the second path carried risk. If a court found fraudulent transfer, the whole structure could unwind. But you also knew that proving fraudulent transfer requires demonstrating he foresaw the litigation at the time of transfer. The divorce hadn't been formally filed yet. The window existed. You moved the assets. 3 properties routed through a series of legal but carefully engineered transactions into LLC sub-entities. You told yourself, every step is documented. Every step is defensible. I'm just doing what any wealthy person with a good lawyer would do. His ex-wife was named Rebecca, 46 years old. She'd given up her teaching career for this marriage, moved 4 times for him. When the divorce settled, she walked away with a house and $3,200 a month in alimony. The 3 commercial properties stayed intact inside the LLC. You never saw her again. But Garrett mentioned once, in passing, that she was looking for substitute teaching work. $23 million versus $3,200 a month. That number sat in your head for a few days. Then it faded. You told yourself, what the law permits is not my moral burden. Your caseload climbed steadily over the next 5 years. You started working with clients whose net worth cleared $50 million. After enough time with that class of people, you finally understood why almost none of them hold assets in their own names. It's not tax evasion. That's a federal crime, and their lawyers know where every line is drawn. It's exposure. At that level, a commercial lawsuit, a product liability claim, a partner's breach of contract can strip everything you've built in a matter of years. Layered structures are their infrastructure, the same way ordinary people buy insurance. You build that infrastructure. The standard architecture goes like this. At the top, an irrevocable trust established in South Dakota. Beneficiaries are the client's children. Trustee is an independent trust company. In the middle, one or more Wyoming anonymous LLCs, through which the client controls the actual assets, but the legal owner is the trust. At the bottom, specific entities holding the real estate, the equity stakes, the bank accounts. From the outside, you can't find the client's name anywhere in the structure. You've spent more hours on these structures than on any relationship in your life. You divorced at 38. No arguments, no drama. She just told you one day that she'd gotten used to you not being there. No children. You live in a one-bedroom in the West Village, lease in your own name, $5,300 a month. One of the few things that actually exists under your name. The irony isn't lost on you. You've spent 2 decades erasing wealthy people's names from asset records, and you yourself have never put a single meaningful asset into any kind of structure. You keep telling yourself, not at that scale yet. Give it a few more years. The real turning point came in year 11. The client's name was Marcus, founder of a mid-size construction company, assets around $40 million. He didn't come to you for planning. He came because a subcontractor was suing him, $2.1 million, unpaid work on a completed project, 14 months overdue. The subcontractor's name was Eddie Kowalski. 53 years old, Polish-American, ran a small electrical contracting company in New Jersey. 11 employees. You read his deposition later. You learned that $2.1 million was close to 2 years of his company's cash flow. He testified in plain language, said his workers had been missing full paychecks for 3 months straight. Marcus still had some assets in his name that hadn't been transferred yet. You had 2 directions. Advise him to litigate in good faith, acknowledge the payment delays, negotiate a settlement, or help him accelerate the remaining asset transfers during the active litigation, so that even if Kowalski won a judgment, there'd be nothing left to collect. Option 1 had a clear price, $1.5 to $2 million, cash flow tight for a year. Option 2 had a murkier cost. You knew what it weighed. Proving fraudulent transfer requires clearing an extremely high evidentiary bar, and you knew how to make the transfer timestamps look, on paper, like they predated the filing. You chose option 2. You told yourself, I'm just completing planning he should have done years ago. Legal equals legitimate. This isn't my problem. Kowalski won. $1.97 million judgment. When it came time to collect, there was nothing in Marcus's name for the court to seize. 3 execution attempts, 3 empty returns. You heard later at an industry event that Kowalski's company ran out of cash within 6 months of the verdict, laid off 8 people, filed for bankruptcy protection the following year. Of his 11 workers, 3 found new jobs. The other 8, you don't know where they ended up. You never looked. You never wrote any of this down. But it didn't disappear. It just got smaller, compressed into something fixed, no longer growing, no longer dissolving, tucked into a corner of your mind you don't open very often. Some nights, working late, the desk lamp throws light across the signature lines on an LLC document, and that thing trembles, faintly. Then you turn the page and keep working. You're 54 now, managing partner, 16 attorneys under you, annual income solidly above $2 million. Your clients include hedge fund founders, early tech investors, heirs to multi-generational agricultural estates. The structures you build for them are legally airtight. Every layer has an independent business purpose. Every document has a legitimate basis. The most important thing this work has taught you: money and a name can be completely separated. The name is the exposed part. It takes on risk, tax liability, lawsuits. The money is the hidden part, protected inside trust agreements and operating agreements, insulated from whatever happens to the name. You help wealthy people perform this separation. You leave the name out in the open. You tuck the money into layers nobody can see. The man sitting across from you today is 39, just closed a Series A, personally holds about $6 million in equity. He's wearing a hoodie that's been through the wash too many times. He doesn't quite look like someone who's used to having this much money yet. His co-founder has already lawyered up for an equity dispute. He came to you today to put that $6 million somewhere it can't be found. You slide the Delaware single-member LLC formation documents across the desk. His hand hasn't touched them yet. You already know he'll sign, because everyone does. In this moment, when they finally understand that their name and their money can be two separate things, they always sign. You didn't convince him. He chose this. You're just the one who pushed the papers across the table. You wait for him to pick up the pen. The desk is cold. Your hand rests on the edge of it, and you feel that cold move through your palm. The same sensation as the very first time you did this, 20 years ago. Back then, you told yourself, as long as it's legal, I'm just doing what anyone could do. He signs. You pull the documents back, slide them into the folder, stand up, and shake his hand. Your name and title are on the card you hand him. That card is everything you own. Under your name, there is nothing.